Good morning, everyone. This is the Vermont House Committee on Commerce and Economic Development. It is Thursday, February 5th, 2026 at 9:01 in the morning. So we're beginning our morning today to have some committee discussions on 639, the genetic data privacy bill. And we have our legislative counsel with us, Rick Stagel.
Sure. Yes.
Morning. And Rick Sagel with the Office of Legislative Counsel. As I await my Zoom invitation, the amendment was posted pretty recently to the committee webpage. So if you haven't looked recently, it should be there now. It's draft 1.1 of the proposed committee amendment to 639. Bless you.
Thank you.
Lindsay, you gonna email me or is it gonna be in the calendar?
Trying to, I didn't create the link,
Oh, okay.
so I'm trying to
It's on
find
today.
it in order to share. So it
It's
might
for
just
today.
Be a minute or two.
That's fine, that's fine. Should I start walking through it or do you want,
It's all the way down at the bottom.
should I wait for the screen to share?
What track number is it? Rick?
1.1.
Okay.
Yeah.
I can't find it. Way at the bottom.
I'll try.
Alphabetical.
Yeah.
Shit on it. Yeah. See if I can find it.
I did change it to Stagel, put it Stagel.
That would be,
And you'd be right at the top.
yeah. My life would change dramatically. Oh, an invitation to, I didn't think it was that funny. All right. Invitation. to
Easy
join.
crowd.
Yeah, it's
Easy.
early, it's almost Friday. All right,
Already thinking about you differently.
Some of us sleep.
Thanks, Tony.
It is Friday.
yeah. All right, I am in the Zoom. Request sharing. Lindsay's gonna give me sharing. All right, thank you, Lindsay. All right, so now on the screen is draft 1.1 of the committee amendment to 639, an act relating to genetic data privacy. Not very many changes from the introduced version. I'll just go through that unless the committee wants a more detailed walkthrough of the bill.
I'm okay with going through it again after yesterday's testimony. I feel like I feel it felt different yesterday when we were downstairs. I don't know.
No, I think it would, yeah, I think it'd probably be a good idea considering we have new context, right?
Right, well,
Ideas about best
I mean, I missed the PRA issue, which made it sound like we had it in there. Which I tried to look for it and I couldn't find it.
So through the Vermont Consumer Protection Act, there is a right of action.
That has nothing to do
If you
with,
don't, but I think if you. That does give access to, just like kids code, that's how we gave a right of
Right.
action, kids
I
code.
mean, it's not the same as the private right of action that was setting up a cottage interest rate.
It's our existing from like the 60s.
Correct.
Yeah, that's
what
what's in
I'm
here.
saying. But the way that they were talking yesterday, sorry. The way that they were talking yesterday, it made it sound like it was the private right of action that we had in the data privacy.
No,
bill
it's the same as kids
earlier
code.
this year, which is why I couldn't find it in there. And I'm like, well, I'm really confused.
It's a reference to 2453, just like kids code,
Which is not an issue because it's already there.
which is what this is, yeah.
Okay. It just, the way that they were talking about it really concerned me. Sorry. I would like to go through it again. Personally.
Okay. Maybe not word for word, but maybe I'll kind of highlight,
That's
because I think we know what affirmative authorization means. Biological sample is a material part of the human, discharge therefrom or derivative such as tissue, blood, urine, or DNA. I've not practiced that pronunciation again, I'm sorry. It's not gonna happen today. Biometric data is a new addition to this draft. This does come directly word for word from the age appropriate design code. There was a request to have, because that phrase is used in the bill, And there was a request to actually have that, what that is defined. And if you have forgotten what that is, it is data generated from the technological processing of a consumer's unique biological, physical, or physiological characteristics that allow or confirm the unique identification of the consumer, including the iris or retina scans, fingerprints, facial or hand mapping, geometry or templates, stain patterns, voice prints or vocal biomarkers, and gait or personally identifying physical movement or patterns. Biometric data does not include a digital or physical photograph, an audio or video recording, or any data that is generated from a digital or physical photograph or an audio or video recording, unless such data is generated to identify a specific consumer. Okay, we know a consumer is a Vermont resident. A dark pattern is a interface that is designed or manipulated to basically subvert or impair user autonomy. You're tricked into doing something. A direct-to-consumer genetic testing company is an entity that sells, markets, interprets, or otherwise offers consumer-initiated genetic testing products or services directly to consumers. Analyzes genetic data obtained from a consumer, except to the extent that the analysis is performed by a person licensed in the healing arts for diagnosis or treatment of a medical condition. Those are your doctors, dentists, all kinds of people that are licensed to practice medicine or some derivative of medicine. Or collects, uses, maintains, or discloses genetic data that is collected or derived from a direct-to-consumer genetic testing product or service, or directly provided by a consumer. Disclose means all kinds of different ways of saying give, assign, sell. Express consent is a consumer's affirmative authorization to grant permission in response to a clear, meaningful, and prominent notice regarding the collection, use, maintenance, or disclosure of genetic data for a specific purpose. Express consent cannot be inferred from an action. Agreement obtained through the use of dark patterns does not constitute express consent. Genetic data is any data, regardless of its format, that results from the analysis of a biological sample from a consumer or from another element, enabling equivalent information to be obtained, and concerns genetic material, includes DNA, RNA, genes, chromosomes, alleles. Is that the correct pronunciation? Thank you. I see one person nodding. Genomes, alterations, or modifications of DNA or RNA. Single nucleotide polymorphisms, SNPs. Uninterpreted data that results from the analysis of the biological sample and any information extrapolated, derived, or inferred. It does not include de-identified data, which means data that cannot be used to infer information about or otherwise linked to a particular individual, provided the business that possesses the information takes reasonable measures to ensure the information cannot be associated with a consumer or household, publicly commits to maintain and use the information only in de-identified form and not attempt to re-identify the information, except they may periodically attempt to re-identify solely for the purpose of determining whether its de-identification process has satisfied this subdivision on the express consent condition that the business does not use or disclose any information re-identified in this process and destroys the re-identified information upon completion of that periodic assessment. And contractually obligates any recipients of the information to take reasonable measures to ensure that the information cannot be associated with the consumer or household, and to commit to maintaining and using the information only in de-identified form and not to re-identify the information. Genetic data does not include data or a biological sample to the extent that data or a sample is collected, used, and maintained and disclosed exclusively for scientific research conducted by an investigator with an institution that holds an assurance with the U.S. Department of Health and Human Services, in compliance with all applicable federal and state laws and regulations for the protection of human subjects in research, including the Common Rule, U.S. Food and Drug Administration's regulations pursuant to 21 CFR 1556, and the Family Educational Rights and Privacy Act. Genetic testing means any laboratory test of a biological sample from a consumer for the purpose of determining information concerning genetic material contained within the sample or any information extracted, derived, or inferred. A person is just about any type of entity, including a individual. Publicly available information also comes from our age-appropriate design code. I think you are pretty familiar with that. I'll let you read that. If you have questions about it, you can reach back to me, but it's information that is made available through federal, state, or local government records. Service provider on page 7. So we have our second change here. Means a sole proprietorship, partnership, limited liability company, corporation, association, or other legal entity that is involved in the collection, transportation. So the previous word was and analysis of the consumer's biological sample or extracted. That was my change. Happy to discuss what that means. It does expand the definition. In my view, that limited a service provider to entities that did all three of those things: collected, transported, and analyzed. I tend to think not all service providers do all three. Some of them probably just transport, some of them probably just collect. So it does expand the definition.
Most giant loophole.
The next change on behalf of the previous word was the, and that was just a mistake on my part, on behalf of a direct-to-consumer genetic testing company. So that's just kind of a grammatical fix. B, on behalf of any other company that collects, uses, maintains, or discloses genetic data collected or derived from a direct-to-consumer genetic testing product or service, or that is directly provided by a consumer. Okay, in the requirements section, privacy terms and consent. To safeguard the privacy and confidentiality, security, and integrity of a consumer's genetic data, a direct-to-consumer genetic testing company shall provide clear and complete information regarding the company's policies and procedures for the collection, use, maintenance, and disclosure of genetic data by making available to a consumer all the following: a summary of its privacy practices written in plain language. B, a prominent and easily accessible privacy notice that includes complete information about the company's data collection, etc. And a notice that the consumer's de-identified genetic or phenotypic typic information may be shared or with or disclosed to third parties for research purposes. And obtain a consumer's express consent for the collection, use, and disclosure of the consumer's genetic data, including at minimum separate and express consent for each of the following: the use of the genetic data collected through the testing for the consumer, including who has access to the data, how the data may be shared, and the specific purposes for which the data will be collected, used, and disclosed. The storage of a consumer's biological sample after the initial testing requested by the consumer has been fulfilled. Each use of the genetic data or the biological sample beyond the primary purpose of the genetic testing or service. And then in the previous introduced version, language was removed. Sure, I have that correct. So there were 4 additional words after service. It said or service and inherent contextual uses. There was a request to remove that and inherent contextual uses because it was kind of vague of what would that be? What kind of contextual uses would that include? So it removes that additional language. It has to be beyond the primary purpose of that testing or service. Any questions about that? D, each transfer or disclosure, again, this is consent from the consumer, that each transfer or disclosure of the consumer's genetic data or biological sample to a third party other than a service provider, including the name of the third party to which the consumer's genetic data or sample will be transferred or disclosed, and the intended purpose of said transfer, except the company shall not require a consumer to expressly consent to the actions in the subdivision in order to receive the services ordered from the company by the consumer. And the marketing or facilitation of marketing to a consumer based on the consumer's genetic data, or the marketing or facilitation of marketing by a third party based upon the consumer having ordered, purchased, received, or used a genetic testing product or service. That last subdivision does not require the marketing does not require a direct-to-consumer genetic testing company to obtain a consumer's express consent to market to the consumer on the company's own website or mobile application based upon the consumer having ordered, purchased, received, or used a genetic testing product or service from that company if the content of the advertisement does not depend upon any information specific to that consumer. Nothing in the subdivision limits, alters, or negates the requirements of any other anti-discrimination law or targeted advertising. Any advertisement of a third-party product or service presented to a consumer pursuant to subdivision 1 or that last subdivision E in the previous section shall be prominently labeled as advertising content and be accompanied by the name of any third party that has contributed to the placement of the advertising. If applicable, the advertisement shall also clearly indicate that the advertised product or service and any associated claims have not been vetted or endorsed by the direct-to-consumer genetic testing company. Okay, the next change is on the revoking consent. A direct-to-consumer genetic testing company that is subject to the requirements previously mentioned about the requiring consent shall provide effective mechanisms for a consumer. This is brand new language to withdraw consent provided pursuant to the subchapter that is at least as easy as the mechanism by which the consumer provided the consent. There was a request to make it clear that in order to, you not just have to offer the consumer the ability to revoke consent, it has to be as easy as the way that you initially requested the consent. So if that's some kind of checkbox, some kind of, however they ask it of you, they have to also allow you to revoke it in the same manner, at least as easy as that manner. And this comes from one of the data privacy bills, that language, that type of language. All good? Okay. 2, if a consumer revokes consent, the direct-to-consumer genetic testing company shall honor the consumer's consent revocation as soon as practicable, but not later than 30 days after the individual revokes consent. If the revocation is related to the storage or use of a consumer's biological sample, destroy that consumer's sample not later than 30 days after receipt of the revocation of consent.
I just want to sink too much into the weeds, but I see a situation where somebody would give consent and the data would be used in some sort of situation. And then they would revoke that consent, but the data at the time when it was given consent, everything was okay. And now they're starting to see ramifications from that situation. I don't know if I'm getting, you know what I'm talking about. In other words,
Excuse me.
Maybe you give them permission to send genetic data to another company. And then later on you revoke that consent, but that other company still has that data. And they got that data while you gave them consent. And then this other company does something nefarious. And now this company that gave them the data is on the hook for it. That's kind of,
The cat's out of the bag, so to speak.
Exactly.
Yeah. So in that case, that data is no longer within the bounds of this bill. So it's with some third party that no longer probably has to abide by, if they are a direct to consumer genetic testing company. You never gave them consent because you gave the previous company consent, who then sold it to another company, right? So in that case, if you revoke it, that company that sold your data or that gave it to someone else, they would delete it, but it's already gone. So I don't know how we would address that.
So unfortunately, once it leaves the company, there's probably not much we can do about it, but it does make me concerned about, because nonprofits do that little sketchy thing where they do the 501(c)(4)s versus the 501(c)(3)s. And they're like super close to one another and they're passing information around, but once it goes over to the 501(c)(3), it disappears. I mean, should we be, somehow fixing that problem? Because that could be a way for the company to scoff with the information and then do whatever they want with it.
So you're saying that they would get a consumer's consent to
And then immediately
disclose it to
transfer it.
to another company that they have an interest in?
Yeah. I mean, I don't know if, because it would then generate revenue for that second company, but all they're doing is they have like basically a shell company, which is, like I said, how the nonprofits and do it with their lobbying activities. And I'm not saying it's gonna happen, but I mean, I could see that happen. Am I not making any sense?
No, I'm thinking about, well, personally, I'm thinking about how that would work. So if you go, and I'll just kind of look at the language here, that for the consent,
So, for example, and maybe this is, as you're sending in your data, it says, do you have a problem with us sharing it with, geneticdata.com or not
.org.
say .org, right? And you're like, oh, well, that's only, looks like they're part of who they are, and then next thing you know, you click yes, your data's done. You're all done. And they can use that as the ability to sell and do whatever they want. They're still making money off of your data, even though they're a separate entity. Is that, I don't, maybe it's just something
I mean, so you can, you'd have to consent to that, as you said, you'd get this consent saying that we are going to transfer, sell your data to this other company. And so in subdivision D, each transfer to a third party, other than a service provider, which would be your example, and the intended purposes of said transfer. So the consumer would, be aware what the purpose would be. So if you want to beef that up, this is where you may kind of want to put some more parameters. I don't know, maybe how you would do that. I didn't think about that, but
it's my looking for a nail to hammer, I guess. On this, I could see where a company starts making second companies to collect the data in Vermont, just so that they could pass it over to their other company, and then they could continue doing business as normal. Am I not making any sense? I feel like I'm not making sense.
I think I kind of understand what you're saying, but I'm wondering, like, even if they take that data and pass it over, like, isn't that still data collected? Like, do we have backstops to already regulate them?
Yeah, I mean, I feel like
I
there's.
think you're going down the fraud line.
Yeah, and I mean, we have, bait and switch and things like, I mean, to me, that's bait and switch.
Right,
Yeah.
yeah, I think we have things that,
But it would be covered under fraud, unless we do that data, see currency. But,
This is protecting Vermonters' data.
right,
Doesn't matter where the business is.
right, but if, so at 23andMe, right? 23andMe creates a sub-organization or a separate organization to only do business in the state of Vermont. And they take your genetic data and immediately transfer it over to 23andMe.
with your approval.
Correct, but
Still
you're
Vermonters data, no matter where the company is.
to. Yeah,
So is the concern that they can essentially just take this data and then kind of transfer it? But I think in order for that transfer to happen, to Evie's point, you'd still have to get express consent to do that sale and transfer.
Even if it's a subsidiary.
So like your initial consent, just because you consented to do the data testing, whatever, is not necessarily enough for them to sell it on. I think.
I think I got maybe a narrower question than what you gave, or maybe you're right, Tony. So we got this definition of service provider. And it's a company that acts on behalf of the testing company itself. And I see we haven't gotten to it, but there's a section on contracts. But fairly limited requirements, I think. Well, I don't know, maybe that's my gloss on it. I'm just wondering is there anything in here that obligates the service provider to do some of the same things that the testing company is required to do? I'm thinking about storage, use, transfer, that kind of stuff.
Maybe when we get to the contract section,
That's
and then we can kind of read that together and see what
That's right.
maybe not there that you want to have there.
Okay.
So we were at subsection D on page 11. Data security and access. A direct-to-consumer genetic testing company shall implement and maintain reasonable security procedures and practices to protect a consumer's genetic data against unauthorized access, destruction, use, modification, or disclosure, and develop procedures and practices to enable consumer to easily access their data, genetic data, delete their account and genetic data, except for genetic data that is required to be retained by the company to comply with applicable legal and regulatory requirements, and request to have the consumer's biological sample destroyed. The data, and so this change here was a typo. It previously said biometric, so it said genetic data and biometric samples. There's not really such a thing as a biometric sample, so we go from biometric to biological. Genetic data and biological samples of consumers shall not be stored within the territorial boundaries of any country currently sanctioned in any way by the U.S. Office of Foreign Assets Control or designated as a foreign adversary. Genetic data or biometric data of consumers, is that?
Biological.
Well, I'm wondering, so subdivision 2 was biological biometric samples. That one made sense. I believe this is the way California has it worded. But I'm wondering if that should be biological samples and not biometric data.
I think a biometric face recognition, retina scan,
Right,
fingerprint.
which includes,
I actually think biometric is more than that. I think it does. I think it is also like cholesterol and.
so let me think about that. And of course, if you haven't had suggestions, we can certainly include biometric data and add biological samples, but there may be a reason that biological samples can be transferred and stored out of the US. So let me put a star next to that, something I want to think about. And something that maybe our Attorney General has something about. Assistant Attorney General, thank you. Any questions about that? Am I just the only one thinking about that, or? Should I?
Yeah, I think that's a good question.
Okay.
Yeah.
All right, so page 12, contracts. A contract between a direct consumer genetic testing company and a service provider shall prohibit the service provider from retaining, using, or disclosing the biological sample, genetic data, or any information regarding the identity of the consumer, including whether that consumer has solicited or received genetic testing for a commercial purpose other than providing the services specified in the contract with the business, and associating or combining the sample, genetic data, or any information regarding the identity of the consumer, including whether that consumer has solicited or received genetic testing with information the service provider has received from or on behalf of another person or persons, or has collected from its own interaction with consumers or as required by law. So, Bolson, you asked about, are they
I'm just
required?
trying to see how that fits in to the, whole framework here. And so obviously, the company itself might want to contract with somebody else to do some of the functions. But the service provider might have the data, maybe I would think. And so, there's important protections with respect to the testing company around, for example, revocation of consent, security, that kind of stuff, holding the data. And maybe I'm missing something, but that doesn't totally seem to be covered in E. In other words, I mean, not thinking of anything nefarious, but there were some specific, I think, protections that we would be requiring a testing company.
Well, the first sentence is pretty powerful. Retaining, using, or disclosing the sample, genetic data, or any information regarding the consumer. So they would be prohibited from doing that for a commercial purpose, right? So I'm not sure what other purpose they would disclose that data for, if not commercial. That's not part of their business practice. But
they still have the data, wouldn't they?
they,
Maybe the security issue is the one that is concerning me a little bit.
I see. Yeah, because they are not,
Subject to the
yes,
security team.
yes.
That's, but it's only for a service contract, right?
Right,
And we have a definition of service provider.
right.
So could it be someone that's outside of that definition?
What do you mean? What do you mean?
Well, so we're talking about them, I mean, I think what Michael's talking about is subsidiary being, so would that subsidiary be involved in collection, transportation, or analysis of the consumer's biological sample?
Could be, but
What if they're not?
then they are not defined. They are a third party.
And how do we treat third party?
A third party is not really regulated in this bill. Only these direct to consumer companies and the service providers are regulated.
Is the direct to consumer company and they contract with third party under this?
And they contract with a third party for something like janitorial services.
Outside of collection, transportation, and analysis of the consumers.
I mean, yes, but I think,
Still has to have your express consent, but
well,
it doesn't.
not to contract now. If any of that contractual services includes obviously things that the service provider would do, they become a service provider. If it's work that does not touch on that collection, analyzing, or transporting, I don't know what else it would be that a third party would do that would involve your data.
I think looking at Michael's scenario,
Yeah.
is creating a subsidiary,
Nefariously.
that doesn't fall under under direct to consumer, doesn't fall under service provider.
Right.
Move the data in order to sell it.
So so the definition of direct consumer genetic testing company means an entity that obviously A is what we all think about, these ones that market to people. B analyzes genetic data from a consumer. But then C is interesting, collects, uses, maintains, or discloses genetic data collected or derived from a direct to consumer genetic testing product or service. So if you are an affiliate of if you're company X and you're not a genetic testing company, as people would think of it, and 23andMe creates this company X, that sole purpose is to be an affiliate, a kind of a loophole. I think company X would become a genetic testing company because they have collected or derived from a genetic testing company genetic data, right? I think they would kind of fit into that definition eventually.
Yeah, no, that, I think that's important. What if the service provider, has the data and then the contract is terminated or something?
Hmm.
And I still have the data. Would they be encompassed within C there? Maintains the genetic data?
Yeah, if it was collected or derived from a direct to consumer genetic testing company.
Okay.
Yeah.
So in other words, if the contract was terminated and the data still is there, they would be treated as a testing company and subject to those requirements.
That is my read. I want some more time to think about it, but that's my initial reaction. Yeah.
I'm wondering if this particular situation would be covered by like parent subsidiary law? Like, sorry, what was I reading here? That if the subsidiary was created to basically just be a shell company
Right.
to kind of hold this, which it kind of sounds like this would be sort of what that's doing, that the parent company would be on the hook for that contract.
Well, yes and no.
Yes and no?
So in some of our data privacy bills, we have affiliate defined. And that makes it very clear that an affiliate, has 50%, whatever, control of a company. So that's something we can consider if you want to add that definition of affiliate. Is something we could also look at.
I think I would. I mean, because it makes sense. I mean, if I was, I'm not saying that brokers are, that they're gonna be nefarious, but I mean, I mean, it's a door that could be utilized.
Laws not consider the best actors.
Right, right.
Will I continue? Okay, we are at, past that. Discrimination. Subsection F on page 12. A person or public entity shall not discriminate against a consumer because the consumer exercised any of the consumer's rights under the subchapter by denying goods, services or benefits to the consumer, charging different prices or rates for goods or services, providing a different level of quality of goods, services, or benefits, suggesting that the consumer will receive a different price or rate for goods or services, benefits, or a different level of quality of goods, services, or benefits, considering the consumer's exercise of rights under the subchapter as a basis for suspicion of criminal wrongdoing or unlawful conduct. Non-disclosure, notwithstanding any other provision in this section, a direct-to-consumer genetic testing company shall not disclose a consumer's genetic data to any entity that is responsible for administering or making decisions regarding health insurance, life insurance, long-term care insurance, disability insurance, or employment, or to any entity that provides advice to an entity that is responsible for performing those functions. Enforcement is the Vermont Consumer Protection Act. A direct-to-consumer testing company or service provider that violates a subchapter or rules adopted violate the section 2453 of the Vermont Consumer Protection Act. The Attorney General shall have the same authority under the subchapter to make rules, conduct civil investigations, bring civil actions, and enter into assurances of discontinuance against any person as provided under Chapter 63.
So, regarding the discrimination, that's not saying, because we all pull up our apps and, as we're downloading, it says you sacrifice your soul to the app company, right?
In 80 pages.
In 80 pages, does that mean that if you say no, you can't be denied usage? Or you can't be charged?
It's saying that if you revoke consent, typically is what this is. Your rights under this bill are typically that you are allowed to not consent or revoke consent to something you've already, as a consumer, that you've already given consent to. So if you do those things, a person, which is anything, right, any entity or public entity as well, cannot deny goods, services, benefits. Like there's this bullet point list of things that they can't do because a consumer revoked consent.
So I've sent my data off to Ancestry. Can't access my account now, but if at any given point I say, I don't want you to use my data anymore. And then they said, oh, that's fine. Now you can't use our platform. You're saying that is that covering that issue? Because or they say, well, that's fine. You can revoke it, but you have to pay. So now what we're saying is that applying to that situation?
Yes.
So what we're doing is we are forcing product out of somebody for nothing. Because our data is about $600 a year per person. Based on my quick search.
Okay.
So we are extracting stuff from an entity without paying for it. And this is where I have my problems with our data stuff. We look at it as, well, these organizations are using our data to pay for the stuff that we get. We get a lot of free stuff, but it's not free. We are paying with our data. Now, this is saying that you can force somebody to work for you for free.
So I don't know if I agree. I would call this more like retaliation. Think of it that way, that if you do something that you have a right under this bill to do, like revoke consent, a company cannot retaliate against you because of that by denying you something that offers every other consumer in the world, like Ancestry. It's open platform. If you pay us, we'll provide you the service, right? So just because you revoked consent or asked them to delete your data does not mean you can no longer log in. They'd have to allow you to log in and access whatever you have left on the platform. So I don't know, maybe I'm missing your point, but.
So, and I guess probably that's not a good example. Because anybody can log in and use it. But if it's a platform, so for example, if I have a bank account and I close my bank account, I can't log into the bank account anymore.
Right.
Right. So, but if we are looking at it from this perspective, you can log into the bank account. I mean, you won't be able to do anything in there.
But this is specific to genetic data. This is you deleting your genetic data. A bank wouldn't care that you've deleted your genetic data, right?
Right. I know. I'm trying to use it as an analogy because they still have to pay for the app for you to be able to access it.
Ancestry?
You can't, well, no, I'm thinking of the banking,
Okay.
the bank account was closed. You still have to be able to access it. you're tapping into customer service if there's a problem with you accessing it. I know it sounds stupid because we don't look at data the same way that we look at money. And the thing is that data is money. It's a completely different mindset. And we have to. So we are forcing an organization to service us when they can't make money off from us. And I understand we don't want them to make money off from us, but that is the deal that if you're getting something from them. It's like Facebook. I mean, if
No,
Well,
this is a
Facebook.
paid to use program.
get that, I get it.
Paying for have them test your data.
But you're saying that you can't deny goods and services. And
So I think in these 23andMe or Ancestry, that when you get a certain amount of availability of their service, because the genetic testing is not the whole service that they provide. They're also providing you the ability to research your ancestry. So you can go so far with that, but then you have to pay more to do more research. So if they're not going to stop you from doing that, you're just telling them to delete my data or my genome, whatever they've got. And you can still, and I think this is saying that you can't deny your customer the ability to utilize your services that your paid services, right?
That they're
so,
paying for it, that the customer paid for.
so for Ancestry.com, because I do have that. When I submitted my DNA, it tells me who I'm related to. So I delete my DNA and and this is saying you still have to provide that information.
You already have it. You already have that information of who you related to.
If you delete your data, then they can't, and they wouldn't be able to use the data to.
They wouldn't be able to, correct, but if,
I mean, I think the intent of this is, if we're gonna continue to use the example of Ancestry.com, is now you tell them I want to delete it, and now Ancestry.com says, nope, you're not gonna, we're just gonna shut you down. And this is preventing that. Because you're now losing the benefit of the other services they offer.
As it says later on, right, they can't charge you different prices. So I could also say, well, some other service we offer, now we're only gonna charge you twice for that, because we delete your data on this other. Which case is calibration, not.
I mean, I think I get your point, which is you're saying that, you don't want, like, and the genetic companies would have to have a business model, right? In which they understand that if you delete your data, you can still utilize services that they offer. They can't deny you that. And the genetic company would just need to understand in their pricing model that they need to charge a price that they would charge somebody who had, when they have their data, or somebody who doesn't, and they're not going to subsidize one price because they have your data and not the other. So the company would just need to understand all of this, and that would be their, and really would help maybe to decrease the monetization of the genetic data. That's nodding, he maybe thinks that's right. I mean, that's how I'm understanding what you're talking about.
so for those paid subscriptions that would ordinarily be a little bit less because the genetic data is being used, we're now charging those customers that are paying more.
I mean, who knows? Who knows what the company would do? I don't imagine, once they don't have your data, I don't imagine there's a lot of services they can provide you. This bill is just saying they can't deny you a service because you deleted your data. But there may be a few services that they could even provide. We're not saying you need to not monetize the data, right? Anyway, that's how I read it. It's more like they can't retaliate. If you delete your data, they can't now say, oh, well, you're dead to me. We will not, let's say there's another service they provide that you want to use. They can't deny that service because you deleted your data.
But if the business model is we are providing that service for free because we are collectively using all the data.
But you're thinking of outside of the realm of this one genetic testing.
Yeah.
You're looking at everything as a whole. The realm of genetic testing is that, number one, you're buying a service to get yourself tested, and then you can also purchase another service to track down your ancestors. So there's no quid pro quo here where you're freely giving your genetic for nothing and they're testing it for you for nothing. You're paying for a service that you're getting the service, and then once you get all your information, you can print it out and you can now buy their service, and you can tell them, now I want you to destroy all my genetic stuff that you have.
I get that. I understand that, but if the business model is that they're using that data for compensation somehow, when you pull the data, that means they can't use it. And if there's a service that they offer free to their users that are sharing their data, they now have to offer it to you for free, even though you're not sharing your data and being part of the whole ecosphere. It's kind of like
I'm not sure what the problem is.
the problem is if the business model is set up so that we offer a free service, but it's not free. It's the reason why we offer is because we use your data, whether that's for advertisings that they can push out to you, whatever. You are saying, I'm retracting that, but you still have to provide me the service. Even though I'm not sharing my data, you still have to provide me service.
Have we heard any testimony from anyone in this field that provides free services for data, for genetic data?
We've had very little testimony on the other side of this equation. It's all been people that are like super pro data privacy. So no, I don't think we have. But the problem is that it's like the apps that we have on our phones, they're all free for a reason.
This is a small industry. And I think you're taking, what this bill is regulating a small industry, and you're trying to extrapolate that into something else. And that's not what this bill is.
But it is our comprehensive data privacy bill.
Yeah.
Ancestry.com didn't, I mean, they didn't flag it as concern. That's kind of,
I get that. It may not apply to Ancestry, and I don't know how many genetic companies there are out there. We're creating a blanket law, and it's all good.
Is the concern about like the free apps that we use kind of on the regular basis having like biometric data about us?
But this is only dealing with, and I get it. I'm just thinking of.
I'm just trying to understand like where your thought process is coming from.
My thought process is, if I'm a genetic testing company, and I offer an app that allows whatever it is, but I use your data, what we're saying here is that even if I would revoke my data from you, you're still gonna have to provide whatever service.
Except they won't have your data.
Correct.
So why
But that's the
would you?
thing. But that's exactly it. Like they wouldn't actually be able to probably conduct the full breadth of services if they don't have your data.
But you can't deny services.
No, you have to make them available, but the question of usability is also there too. So if they don't have, the data because you've retracted your permission, then they don't have anything there to like run tests or comparisons or anything like that. Like you might have the results from what has been done previously, but going forward.
I think of the term retaliation
Yeah.
and what that means. And I think it's a little more narrow than I'm hearing you say, Mike. I mean, if the company that you got your DNA testing from and you got the results of that and you paid for it, well, I guess you're thinking that they're not paying for it. But, assuming that they paid for it. And then they offer these other services. But they can't offer those other services because they don't have the DNA data. Is that what you're talking about? And I don't see that as retaliation. That's just physically impossible. I mean, if you actually needed that data to perform these other services, to me, I don't know the law around retaliation, but that doesn't strike me as, well, we're not going to do this because you revoked your consent. It's just physically impossible to provide this other service without the data that I got.
No, yeah, and if the customer were to go back to the company and say, I would like this test again, I give you affirmative consent to do so. Now, if they said no, because you like canceled once.
I think, can I take a stab? I think I get what you're saying. Let's say we have 1,000 people in the state who submit their genetic testing to ancestry.com. We have 1,000 data sample of 1,000, and they all pay $50. 500 of them, 2 weeks later, download their data, go in, delete it. And the company now has 500 that they are then putting in a pool, right? And they're monetizing that. Maybe they're allowing drug companies to search it. I don't know what it is, right? But they have 500, they don't have 1,000. So they make half as much money doing that, right? And so maybe because of that, they have to increase the price of, instead of $50, it's $55. So now those 500 customers who are sharing their data are not subsidized by the sharing as much by the sharing of the data. So it could increase the price for the customers by a little bit because they're not used as much. Is that what you're trying to say? If that is, I'm fine with that. I think that's a perfectly fine trade-off.
It is, that is kind of what I'm saying, except for it's a situation where they offer whatever service because they have the data.
Yeah.
And what I'm saying is that those 500 people, if they withdraw their data, they can't say, well, that's fine, now you have to pay to access whatever tools we have or services.
Yeah, no, I get your point. I just don't agree,
That's okay.
but I get it. I mean, I think, yeah.
Well, I have one more thing. We're focused on deletion. A customer can also request you not sell their data. So in that aspect, the company still has your data. You've said don't sell it. The company then couldn't say, well, because you didn't allow us to sell your data, we're going to charge you more, or we're going to deny you this that everyone else gets. But because you said no, we're going to. So think of it. It's not just deletion of data. It's also the consumer saying, don't sell it, don't disclose it, don't give it to an affiliate without my consent. So think about that too.
Basically saying my genetic data is not current.
And you can't retaliate because a consumer has invoked that right. Shall I continue? Any questions about enforcement?
Yes.
I need a Cliff Notes version at 2453 vis-a-vis.
Okay.
Who has standing?
Yeah.
And what steps are available to them under 2452 to seek redress?
So this may be a bigger conversation, but just kind of Cliff's Notes, it's the Vermont Consumer Protection Act.
Right.
An unfair act in commerce, as typically defined as the FTC, the federal government's, how they define what an unfair act in commerce is. And of course, we cross-reference that a lot, and we say here that this thing is an unfair act in commerce. If you sell genetic data that a consumer has told you not to sell, you have violated our Consumer Protection Act, which gives the Attorney General the right to enforce on behalf of the state. Vermont would sue Ancestry.com or 23andMe, whatever. A person could also invoke their private right if they don't want to use the AG, or if they think that they have been harmed so much that they're going to sue the business on their own. The Consumer Protection Act allows that as well. So there's a few avenues.
But it would have to be somebody who was aggrieved or
Yes.
allegedly aggrieved. And
You can file a frivolous lawsuit, but no, that would be a waste of time and money for the consumer to do that. You would need to have harm and indicate this is how I was harmed, you violated this, and then the court will take it from there.
Thank you.
Mhm.
Perfect.
Great.
Yeah.
Express consent.
Express consent.
So is that like a blanket, check a box and you can do whatever?
Thank you. We have it defined. Look at that again. So it means a consumer's affirmative authorization, which is also defined, so there. An action that demonstrates an intentional decision by a consumer. Okay. So some type of intentional action by a consumer to grant permission in response to a clear, meaningful, and prominent notice regarding the collection, use, maintenance, or disclosure of genetic data for a specific purpose. It cannot be inferred from an action, which to me indicates you have to, click something or sign something with your mouse or finger. Agreement obtained through the use of dark patterns does not constitute express consent.
So if genetic tech company sells your data for monetizes it, is that allowable under that one box you check?
You would have to, let's make sure here before I say something. Collection, use, and disclosure, at minimum express consent for the use, who has access, how it may be shared, the storage. So, selling it does not require anything special other than just what the definition of express consent is. That's my reading of it. So if we want that to be a special event, then it would need to be,
D, page 9D,
Mhm.
9 blank, is that where you are?
yes. I have it up on the page.
Oh, sorry. I'm stuck in on mine in front of me. It says that you do need it, doesn't it?
Yes, but I think the chair is indicating that is it just a regular consent that a consumer would,
Blanket consent.
it would need to be,
Oh, shall not require a consumer to expressly consent. Yeah.
Emily, that's correct. There needs to be a box for each of the things, but selling the data would be one of those boxes. Yes. That's my view of it. We didn't get to the applicability. Happy to, there's no changes. Make sure there's no changes to the applicability. You have your typical HIPAA exemptions, scientific research, and then public information. And let me show you the one that got a couple questions last time. I didn't change it, but on the last page, subdivision 6, genetic data used or maintained by an employer or disclosed by an employee to an employer to the extent that the use, maintenance, or disclosure of that data is necessary to comply with a local, state, or federal workplace health and safety ordinance, law, or regulation. That is exempt from the bill. Sounds like we have some decisions to make on that.
If you like. You had something else that you wanted to bring to our.
So, and yeah, I have, thankfully the Assistant Attorney General is here. Maybe he can explain this. So I thought this morning about law enforcement and how occasionally they will request this information from Ancestry, 23andMe in police work to conduct some police work. You hear about these cases where they solve a crime using DNA through a cousin or a sibling, and they eventually get to the DNA sample. Even if the person didn't do it, they have a relative that used Ancestry. So my reading of the bill, if law enforcement gets a warrant and submits the warrant to Ancestry, would Ancestry have to get your consent to disclose that? Again, my opinion is I don't think it's clear. So if I was the counsel for Ancestry and they get a warrant and they ask me, do we need to get the consent of the consumer? I would say, well, Vermont passed this law that says you have to get their express consent. There's no exemption for law enforcement. So I told the chair about this, and I said I could talk to my judiciary colleagues about this because it's kind of out of my wheelhouse as far as warrants and about law enforcement. But there's, may not hurt to think about if you want to include an exemption for law enforcement with a warrant, might be something to consider. Thanks for the reminder. I was distracted.
When we had Todd up, we can go over that later. I think something else that came up yesterday, I missed a lot of it, but is a cure period. Something you all heard about yesterday. Discussing that. And I think Tom Weiss has a suggestion that he'd like to bring to us. Tom, if you'd like to join us. Put him on the agenda. Put Todd up.
Morning, I'm Tom Swice, a resident of Montpelier and a civil engineer, and I appreciate your giving me a few minutes, shoehorning me into what might or might not be your last session on this bill. And this morning's testimony goes back to my testimony last week on H211. I have not heard why this is being placed into a separate subchapter 61A instead of making it a separate. Anyway, it's a new chapter 61A instead of into a subchapter of the existing section 62 or chapter 62, pardon me. And my experience as an engineer with contracts and specifications and drawings is that repetition can cause problems and in some cases significant problems. Last week, I recommended that you move some definitions around within chapter 62. And I asked that definitions of terms used in more than one subchapter be placed in the subchapter 1, which covers the entire chapter 62. And now, I see that genetic data privacy is really a subset of chapter 62 and not a new subchapter. H639 will create two distinctly different definitions of genetic data. This will cause, and I believe my letter has been posted on your site for today. Okay. And it's that comparison of the two definitions of genetic data that is my concern. They're not the same. Some of them are significant differences. Epigenetic markers are no other there. or other sources have been removed. And there are slight changes in words. And my experience with contracts and specifications is that whenever you say the same thing two different ways, it creates loopholes and unnecessary confusion. So, and even if you were to change the definition in H639 to match the definition that's now in Chapter 62, then sometime in the future, some legislature is going to change it and create the confusion. So what I'm suggesting is that you move what is in Chapter 61, genetic data privacy, into a new subchapter in Chapter 62 and make the definitions uniform. I don't understand why genetic data should have two different definitions in two different chapters. I think it should all be the same. And, the Chapter 61A definition has a whole list of what's not genetic data, which is not in Chapter 62. So a company that's working in both realms, which do they have to follow? Partly, I guess, depends on context, but I'd rather that not happen. So that's my comment today, is that I don't see why it's a new Chapter 61A, and that it should be a subchapter in 62.
Thank you, Tom.
You're welcome.
It's a question for our legal counsel.
Want me to respond? Okay. So I missed that conversation. I think last week you were here about that. So I haven't had a chance to digest that. I thought about putting it in 62, which is where you have the age appropriate design code. You have the Security Breach Notice Act, you have the data brokers. To me, and it is a legislative council decision, by the way, I want to lead with that. To me, the way I'm thinking about this is you're going to have some type of data privacy law, probably at the end of the session. And we're not going to stick data privacy in Title 62. It's not going to work. It's that title was meant for initially security breaches. That was the point of that title when it was created, or that chapter in that title. So I did think about putting this genetic privacy in there because it is public personal information. However, with the genetic data definition that is in that title, that is, by the way, only used for the age appropriate design code. That's the only time that definition is used, is my understanding. So I can look at it again, but I looked at it several times when I was actually doing this. And I'm thinking I do want data privacy to have its own chapter because it's going to be a comprehensive type of thing. And this genetic data privacy would live in the data privacy chapter, which, again, will presumably have a comprehensive data privacy law. So, but again, I appreciate the analysis, and I'm glad someone else is looking at the green books along with me. That's helpful. And I really am trying to keep it as clean as possible, and also thinking about the future and where we're going to put these things. So, and I know Rep. Olson, you may have some suggestions too with your history, but
I'll leave that for you.
okay.
I mean, I haven't wrapped my head around what specific definitions in the existing chapter 62 might be in conflict with what we've got here. So I don't really have my head around that.
Yeah.
And I think what you're saying is that there's no conflict to the extent that they're different because you're dealing with a different subject matter. That's what I'm hearing.
Yeah, when you have a chapter and you have a subchapter that has definitions that apply to every subchapter in that chapter, which is what 62 is, you put yourself in a box, and sometimes you don't want to use. Consumer is a great example. We typically have the same definition of consumer, like that's pretty but ubiquitous. But this is a specifically genetic data privacy law where it might be more detailed than you want than the age appropriate design code genetic data. So I think I have faith that our businesses will know where to look for compliance and how we expect them to comply. But that's my opinion.
Thank you.
Morning.
One.
So nice, I guess. For the record, Todd Delos, Assistant Attorney General at the Vermont AG's office. My apologies for missing the first part of markup, but happy to answer questions if there are elements I missed. The three things I noted down were a question about warrants and law enforcement access to the data. Maybe a further thought to your question, Rep. Bosch, in terms of sorry, Booten, but in terms of that discrimination question you were asking about. And then I'm happy to share our thoughts on a cure period. Were those the main three? You know, on the warrant point, I would say I looked at both Virginia and California are sort of the main models for this. Neither of them have an exclusion for warrants. I think in the cases like the Golden State Killer, which I think is sort of the big famous one, a lot of that was crowdsourced, right? So individuals choosing to engage on their own with their own data and sharing information and looking. I don't think it was a law enforcement seeking information from a testing company. So that's just by way of thinking those two pieces through. The third piece I would say is, you know, any kind of broad access to law enforcement would be concerning without a judicial check. I don't know if I need to talk more about why that might be of a special concern in the current moment, but we would certainly say that would be really important. And I would almost say if it's something the committee wants to engage in, I would look to Ancestry and the industry to see to what degree they're concerned about that. From our perspective, of course, we want to enable law enforcement to carry out their investigations in an appropriate manner. We trust Vermont law enforcement. That's not a concern. And we just wouldn't want to open the door too broadly in case there are unintended consequences there, or we're solving a problem that law enforcement may not see. That's warrants. On the discrimination point, Rep. Booten, I think other folks talked about this. And the committee discussion sort of responded sufficiently, so I don't need to open that again. I would say the way we look at that, if you don't pay for the service, you don't get the service, right? If it's a fee for service. And I think we heard yesterday from Richie, you know, the three big players, that is how they operate. They're not in the free data, or rather it's never free, right? That's what I tell my kids all the time. I prefer we pay for the app than you get the free app, because the free app is just, you're paying for it otherwise. Be amazed how little a 12-year-old cares about their data. So putting that to one side, I think there were a number of examples that I would just re-highlight, because like the way I read that provision is, a company can't offer a gold level membership if you waive the express consent requirements for any transfer of your data, right? We'll give you all this additional benefit for no extra cost if you waive these rights. That's kind of the main piece. Or if you exercise the rights and you say, I'm not going to consent to you transferring the data, they can't say then you don't get to use the system anymore, even though you're paying the $600 a month or a year. That's how I look at it. I'm not aware of a business model that is, it's free if you agree. That would be prohibited. And I would say the same language is in California, same language is in Virginia. And the way I look at it, industry's not paying that much attention to 635,000 potential consumers. They're going to pay a lot more attention to the fifth largest economy. So to the extent that helps provide a little support. The cure period, I mean, I said yesterday, our general position on this is any kind of disclosure that's not authorized and is a violation of the law, I just don't think there's a cure. I mean, I think it's as simple as that. Once the data's out, the data's out. Now, what Ancestry said yesterday, I think is important to think about, but I will just give a lawyer's perspective, this lawyer's perspective on it. If my data gets out there after I've engaged with Ancestry and I sue Ancestry under this law, if it were passed, and Ancestry said, whoa, we used this lab and the lab had the breach, you should sue the lab. That's something that's going to work out in litigation. My engagement is with the company I'm engaged with. Now, they may have a contractual agreement with the lab that requires indemnification. I hope they do. There may be an additional action against that other company. I may have sued the wrong party, but that doesn't mean that there shouldn't be the ability to seek redress when your information is disclosed without your consent. And so that's what we'd say is, we don't believe there should be any kind of cure period for any kind of disclosure, right? You sue the wrong party, they're going to get it dismissed. That's how the legal system works. I understand, the question about minimizing litigation. I think this committee's heard that a lot. I think Rep. Cooper asked a really valuable question. It's like, who's tracking that data? Is the AG tracking that data? What are you seeing it from? I will say anecdotally, again, we don't see it in Vermont. We don't see a lot of that kind of vexatious litigation. I didn't hear about it happening in Wyoming, which is another state that has a private right of action in the genetic data space. So I don't know if we're hearing about, a concern that is existent or one that is somewhere out there. And, I can imagine a world in which some of the more technical violations, was this a clear and conspicuous notice or not? When we bring an enforcement action, we're going to have that conversation, right? It's cheaper and easier for Vermont and for the business to come into compliance fast. That said, if you see it a lot or you see a business practice, you stop providing that prosecutorial discretion. But we feel like where we sit as the AGO, that cure period is already our business process by and large. So we don't see a need for it, but I recognize that's something the committee is going to want to discuss.
Can you talk me through, so I'm a consumer. I feel I had an account with one of these companies. My data got out there. I personally get a lawyer and sue them. And they respond to me, not to you, right? So this is without a cure period. They respond to me and say, your claim is false.
So there are a lot of different ways it could go. I think most lawyers would send a letter to the company saying, my client is this person, here's the information, we believe you're in violation of this, and we believe there's, here are the damages under 2461, which Rick laid out in response to your question. And then there'd be a negotiation, a conversation around that. I think it's not frequent that a lawsuit is the first step in that, but again,
And then if there's a cure period, I send them a letter that says, I think you violated my data. I think you did something with my data. And they reply back to me, we have 15 days to look into this. Is that the difference?
The difference, well, I think there could be a number of different.
And I'm just making up.
Yeah, so if we can go into the concern, I'll give you the hypothetical in the concern space, not the not concern space. The not concern space is, yes, they fix it, everything's fine, nothing bad happened. The concern space is, you send that letter, they've had let's just say it's like their notice is not clear and conspicuous. And so however many customers who have engaged in that not clear and conspicuous notice to the point in time where you sent the notice letter have consented to something that wasn't clear or conspicuous, was in violation of the law. Maybe they agreed. Maybe it was a one checkbox on a 50-page terms of use that allowed for free transfer to any number of third parties, or allowed disclosure in other ways, or use for other purposes. If that, it's the clear and conspicuous notice. So they technically haven't necessarily violated the transfer part of the law, right? Because you consented to it. But of course, you didn't really consent within the meaning of the law. So some kind of damage may have occurred during that 15-day, but they could be selling all that data with your consent for 15 days to every data broker out there or wherever else. Again, I don't believe Ancestry would ever do that. I think most of the actors in this space are totally reasonable. But that's the scenario, right? You can still have a technical violation. You can have a 15-day period, and up to day 14, 23 hours and 59 minutes, they're still operating within the bounds of what is appropriate. And then, again, these are very savvy companies. How hard is it for them to make that technological shift to make something more clear and conspicuous et cetera. So that's the reason it's different.
Thank you.
And theoretically, until that 15th day, you don't have a claim for whatever damages occurred.
Couple of questions. Retaliation and what that means. And I was positing, so a consumer revokes consent. And that would confer an obligation to destroy their data, right? And I'm thinking, well, the company might need that data in order to perform some other services. And would they be able to say, would it come within the definition of retaliation for the company to say, well, geez, we can't provide those other services because we don't have the raw material?
Recognizing this as a hypothetical and not making a statement about any future enforcement action should it happen, I would agree, right? I mean, I think, I'm not sure if it was Rep. Duke or not, but if you don't pay, it's not retaliation to say, well, you're not paying for the service, so you don't get the service anymore, right? Similarly, if you don't, and I think this was both you and Rep. Karis Duncan, if you don't have the genetic material that can't provide the service, that's not retaliation, that's an impossibility, and that would be the defense. I think retaliation would look much more like, you wouldn't allow us to transfer the data. We're going to charge you more. We're not going to give you access to what you had access to previously.
Another question?
Yeah, I'm trying to keep it to the cure period, but we've already gone down. Let's finish it.
I can wait.
Okay, go ahead, finish it.
Oh, okay. I was thinking about the warrant issue, and you got state law enforcement, you got federal law enforcement. And there might be a difference in level, but you talked about trusting the process in terms of that warrant and the standards around that kind of. And I would agree with you around state enforcement. I have a little qualms these days about some segments of federal law enforcement. What's the question? Yeah, but in any event, I know very little about common. And if we want to explore that, we should probably ask others. Sorry. Bridget, didn't know what
Yeah, may I just weigh in for a second? Bridget Morris, Corporate Strategy, also here on behalf of Ancestry, and I think you heard in Richie's testimony. I just wanted to clarify one thing that, in Wyoming, under that cure period, there has not been a frivolous lawsuit, but I would say under the genetic and biometric laws in Illinois and the PRA available there, they did have a number of lawsuits that were threatened against them that did not actually turn out to rule against them ultimately. But so it has happened in the past. And I think, the valid reasons for wanting that kind of cure period that exists in Wyoming. And one could say part of the reason they don't have those frivolous lawsuits is because there is that cure period, which offers that extra hurdle. Just wanted to clarify.
Bridget, can you get us information from the industry on police warrants for?
Yes, I would just say that I actually had to look through the bill again because I think we assumed that it was in there, but I think typically in other genetic privacy acts, which I need to reconfirm this, but that it does mention that there is an exemption for law enforcement in a valid legal process. But if you want, I can try to find, I've reached my client at some point in the next 24 hours to discuss what other states have that in there now.
Yeah, I didn't see it in California or Virginia, which is just what happened.
It's not in California.
It's not.
So again, Rick Sagel, Special Counsel, I'm quickly researching this. Montana has requiring a search warrant or a court order. It's not clear if, based on this bill, a search warrant wouldn't necessarily. I think Ancestry may have its own policy of requiring a search warrant, right? But that's not law. That's their own policy. So it's nice that they have that policy, but not every company may have that policy. So, absent a policy, if a company receives a request from law enforcement, if this bill were to pass, then My reading would be they would need the consent of the consumer, and maybe you want that. I'm just saying it's something to think about.
Regarding that. If a court requires it, they can't refuse it, right? Like, I mean, court says, we want this information. Can't say no, right? Like, I feel like that's,
So think about iPhones and think about search warrants that Apple fought for a long time about how to crack an iPhone to get information for law enforcement, right? I mean, it's a lot of litigation. I'm not an expert in where that might play out, but I think a company would want to be really careful about whether, in response to just hypothetically a New York search warrant on a Vermont consumer, whether they're going to fight in New York court over that warrant, or they're going to fight in a Vermont court over disclosing data in violation of Vermont. Again, I would want to hear from the industry about how frequent that is. I think the scenario, and I'm looking at Virginia and California, I don't see it in those two states. I just don't know if this is a solution that doesn't really have a problem behind it or not. And there may be a carve out exactly along your lines, like, oh, it turns out in this space, the court gets say so. But again.
I have a novice question. Since Vermont has had our consumer protection law for quite some time, do we often get an influx of would-be frivolous lawsuits?
So I spoke to this a little yesterday, and Jonathan Rep. Cooper asked a great question, which is, do we track that? We are not aware of that happening. Okay. That's the short answer. There's not, I was talking to another lawyer earlier this morning about, how you would go about, there's not an easy way to search all the dockets and all the cases, but it is not something that we're aware of. We certainly don't see appeals and things like that, because I think generally we have notice of what's at, the Vermont Supreme Court is a sort of focal point to pay attention to rather than every superior court in the state, but we're not aware of it.
so I guess I just don't understand the legal processes. So if a judge says you have to hand something over, a company can say no.
There's appeals processes through that.
Oh, okay.
And also they're a person legally. A company is a person, so they still have the same rights as a person. And they also technically have a right to privacy.
By way of example, there are times that the state gets sued for various reasons, and we may get a subpoena, which is a kind of private warrant. And we might fight those for various reasons. Judicial orders, we are less likely to fight, but we also have a little more flexibility as the state. I think, there are certainly examples out there. Another one would be freedom of the press, right? Another one that's germane in the current moment. That's a similar.
So, right, putting in an exemption would make it easier for people to get that. And it sounds like other states haven't done that.
At least the two that I have static copies of their statutes in front of me.
My opinion. I would say,
Well, I mean, that's.
if it's not broke, let's not fix it.
That's a question that's one of the questions we asked in the person. And the other question is the cure period. So let's start with the cure period, get 10 minutes. Let's start that discussion. We're definitely not going to finish this up today, so. Where are people at? What are they thinking about? Do you want to include it? You can stay there, Tyler, it's fine.
I can start. I think there should be one. I think, to me, any sort of speed bump to prevent frivolous lawsuits is good. To their point, there were in other states frivolous lawsuits, and okay, maybe they didn't amount to anything, but those companies were still sacrificing time and resources and manpower to fight those. And I think to put a little bit of a speed bump in there, yes, the cat's already out of the bag, but how much more? I mean, it's already, I don't know, is it 15 or 30 days is gonna make much of a difference.
I guess the cat's already out of the bag. How do you cure it? Right? That it's supposed to be a cure period to fix something. How do you fix something that's already out?
Well, I think it allows, yeah, I guess the question becomes, is the cat really out of the bag? And that gives some opportunity to figure that out.
So I would agree a cure period is is fine. I don't know. Once it's out of the bag, it means it's in the possession of a third party, so there's nothing you can do about that anyway. But, you know, allowing time when it's obviously cutting down on lawsuits in other states, I think that's probably a good idea. I will add in, I don't know if I want to put an exemption for law enforcement if it's already taken care of.
Let's stick with.
Yes, sir, sorry.
Anybody else want to wait? Kurt?
So the zero period, when we're talking about that, we're talking about limitation on a private right of action, right? For limited period of time. And we're also talking about retaining, you know, whatever enforcement authority the AG has, right? I think that's encompassed within the cure. And on the latter point, I think these our agencies needing us as enough help, as much help as they can to address. You know, these are pretty complicated. I know it's just a few companies, but these are pretty complicated issues that I certainly like to have the expertise to do that. You know, to respond to a claim, or whatever. I'm not sure that they have that resource up front to do that. On the concept of the cure itself, it just strikes me that the data is so personal, is so wrapped up in who you are. I'm a little worried about putting limitations on the ability of an individual who's really upset. You know, maybe not a technical violation, but it really goes to the heart of what we're trying to do here. So I'm a little reluctant, but I'm willing to listen.
Jonathan?
Good morning. One of the things that I'm thinking about with respect to cure periods is if the accuracy that we've talked about if these things are as precise as we presume them to be or have been speaking about them as, are requests ever coming from the wrong people that don't have standing or who may be misunderstanding which individual's data or something like that might be part of the breach? I'm curious to hear if that's a relevant factor. The sort of mistakes in a presumption of that the accuracy of what we're sort of talking about. Is it 100% all the time, and therefore any request being made or notification being made is automatically correct? Or is it something where there is human error on all sides, and that's sort of what a cure period can help ascertain?
I guess I generally not a fan of the cure period because of the weight of the data that is being collected, and but I would say, like, I also think it sounded like from the witness yesterday that, like, I would assume that a company that gets this information that is like, we're going to be sued, would check right away. So if there was going to be a cure period, I don't know why it couldn't be something as small as like 48 hours or something. But I also just politically, I'm just curious if we want to do a cure period on the House side when this will be lobbied also on the Senate side, and that could be an easy gimme for the Senate to add. as well. So. For the record.
I think a briefer time period, I think, Representative, that makes sense to me, that it doesn't need to be 30 days. I think what we're talking about is something that is very automated. And I think the fact that these periods exist elsewhere means that people have systems in place. And I doubt that anyone needs more than, I can see 48 hours being a sensible number. But I also take your point that this is the beginning of a negotiation between chambers.
Yeah, I mean, I guess I agree. I think I'm fine with the cure period, but I think it should be short. 48 hours, 2 business days, that. And
I hear the fear about frivolous lawsuits. That if I'm comparing the damage done to an individual versus the damage done in a frivolous lawsuit, I'm going to weigh on the side of the person, individual. So for me, the frivolous lawsuit question is not an issue. The whether or not someone is trying to that doesn't have standing or that kind of thing, one would presume that they have an attorney that would be helping them with that, making that decision, right? So I feel like either a cure period is not necessary, because as we've heard, the data is already out there. And so if we were going to do a cure period, I still think, yeah, it would have to be short, very short, 48 hours, 24 hours, something, just long enough for them for the company to look and say, yes, oh yeah, we see that there's a problem, or no, we don't see there's a problem. But I don't think it doesn't strike me as the kind of thing that would require a lot of consideration on their part. They should have that data available.
You want me to talk?
You'd like.
Normally, I'm a huge fan of cure periods. I think they make a lot of sense. And I have real concerns about this specific data needing a cure period. And so when we refer back to the BIPA, the Biometric Illinois law that was 2008, it was a really badly written law that didn't get updated for more than 10 years. And that's why they had so many court cases and needed cure periods and had to do all kinds of things. This is a law that is in effect in 14 other states, pretty darn close to exactly this. I'm not sure we need it here, so.
When I look at the term cure period, that means we're giving them time to fix something, right? Can't fix something that the cat's already out of the bag. How do you fix that? So why should we have a cure period to fix something that can't be fixed? I want to take you back to last year. We did kids code. We didn't include the cure period in there because we understand the reason why we shouldn't have a cure period and the reason why we have a PRA in there. Because that's bad stuff. Same goes with your own personal genetics. If it gets out, that's could be really bad stuff. So why wouldn't we give a person that has that arm the ability to sue? I understand it in the broad context of data privacy. And wholeheartedly supported a cure period. Because those things can get fixed. You can stop the company can stop doing whatever they're doing, sharing your data. This is a little different. This is your genetics. So I mean, if the committee's willing to provide a cure period, I mean, I'll go along with it, but I don't see a need for it personally.
Honestly, that makes sense.
Yeah, same.
I guess for me, I keep thinking about kind of the forward technological world that we are wandering into. And having this level of, I mean, highly sensitive, I don't think even gets to it. Like, to the point, like, this is you, the making of you. And so I don't know, we're going into a blank space. I'm not sure what's gonna happen, but there's a lot of very powerful technology that's being created. I think we need to be mindful and protect people. And I also really do agree with the point that in this situation, when the information is out there and given how fast information can be disseminated, it's kind of out there. And it's very hard to get back into track. I also trust what the AG's office is saying. It seems like they feel comfortable being able to handle it. So I don't know that a cure period is necessary. Yeah, I don't think it's necessary in this case.
Jonathan, did you want to say anything?
I think I should, just to clarify, it doesn't, a cure period doesn't preclude people from suing. It just does for the length of the period. Is that correct?
It slows down the start date of the lawsuit.
Yes, and I just, part of my thinking was the cure period both is a cure, to provide a remedy. I also understood it to be, we have entered a serious phase in which legal counsel on both sides are communicating with one another. And there is, it seems like I didn't see that period of time as impeding somebody's actions so much as sort of pre-flight, like taxiing on the runway, and preparing for those actions, which should only be done, I think, in consultation with qualified legal representation. That's why I felt pretty comfortable with a very short window of time, as opposed to something that our witness seemed to believe was much more time than was necessary. Thanks.
I think that's part of the process. You file suit, your lawyers are gonna have that back and forth. And so, I think as Todd brought to us, and I may have been Edie as well, that there's the longer you let it sit there, the more time they have to continue to conduct whatever frivolous thing that's going on until you get to that stopping point. So I think the minute you file that suit, then hopefully they're taking a look and saying, uh-oh, made a mistake. And it stops. So we have to go, but committee, I'd like you to really think about the two things that we discussed. Warrant and cure period, and we'll set some time up for sometime early next week, maybe late in the afternoon, or we may come back after caucuses in the afternoon. We've got to start moving. So let's think about that. Maybe we can take a little time tomorrow to have further discussion. We need more drafting, we can get it through it. Okay, with that, we're over in room 270 for hearing for the outdoor rec.